Hello, everyone. Good morning, good afternoon, and good evening, depending on what time zone you're located in. The INCBA membership and community really does span the globe. So I always like to start our welcomes with that, just as a special warm welcome to our members and our attendees who are in time zones where it's actually nighttime or evening. My name is Shahida Shabazz. I am the executive director of INCBA, and I'm excited to welcome you to today's emergency webinar on the recommendation for the DEA to reschedule marijuana under the CSA from Schedule 1 to Schedule 3. Just a quick overview of INCBA. It was founded in 2015 as a membership organization for cannabis attorneys to educate and connect cannabis attorneys and to positively impact the regulated cannabis industry. Since its incorporation, we've grown to over 800 members. Our online and in-person programming has expanded to include CLE credit and also, as of this year, foreign continuing education credit. And our annual Cannabis Law Institute has become an unparalleled deep dive into all things cannabis law. And we've become the go-to network for cannabis law students, attorneys, regulators, and professionals. Hopefully, many of you who are attending are already members, and so you're already very well aware of all of these things. And as a special thank you for attending this webinar, I'm excited to announce that members who register within the next 48 hours will receive a $200 discount to our upcoming Global IP Symposium, which will be in Montreal, September 28th and 29th. It's a special flash sale for our members. So if you're not a member yet, that should give you an extra incentive to join today. Now, the reason that we're all here today, this is a very, very exciting development in the federal regulatory saga that has been going on in the US for years. And I am not going to keep you any longer because we do have a lot of ground to cover today. So I'm going to turn it over to Jason Horst, who is the board president of INCBA, to introduce our speakers and kick off the discussion.
Thanks so much, Shahida. And thank you all for joining. We have just incredible participation here, and I think it's because presumably everybody who's interested in this industry and the legalization movement is now well aware that news broke about a week and a half ago through a Bloomberg News report that was quickly backed up by other outlets that the U.S. Department of Health and Human Services had sent a formal recommendation to Ann Milgram, the DEA administrator, recommending that cannabis be rescheduled from Schedule 1 to Schedule 3 under the CSA. And by exactly 4:20 p.m. Eastern Time, HHS Secretary Javier Becerra had taken to the social media platform formerly known as Twitter and proclaimed that I can now share that following the data and science, HHS has responded to POTUS's directive to me for the department to provide a scheduling recommendation for marijuana to the DEA. And then the entire cannabis world went collectively nuts. Hot takes galore, confetti flying in certain corners of the industry, borderline despair from some legalization activists, and publicly traded cannabis stocks soaring as much as 80% that very day. Assuming that the reports are true, and all indications seem to be that they are, this would mark one of, if not the most significant developments in federal cannabis reform since the CSA was enacted. And as such, INCBA has gathered some of the very best legal minds in cannabis on this topic, as well as myself, for an in-depth discussion about what this means, what it doesn't mean, whether we should cheer or fight it, and what comes next. And so with me today are Amber Littlejohn, Khurshid Khoja, and Shane Pennington. Amber Littlejohn is of counsel to Ice Miller, where she provides regulatory, government, and business affairs services to businesses, nonprofit organizations, and governments in highly regulated industries, including natural consumer products, dietary supplements, and notable for today, cannabis and hemp. Prior to joining Ice Miller, Amber was the president and chief strategic officer for a public affairs firm that provided solutions in the areas of legislative and regulatory policy development, as well as government and regulatory affairs. She's also served as counsel, staff, and consultant for a number of organizations in Washington, D.C., including the American Herbal Products Association, Natural Products Association, and as the executive director for the Minority Cannabis Business Association. She served as a board member of the United States Hemp Authority and convening officer of minority engagement for the United States Hemp Roundtable. But most importantly of all, Amber serves as the vice president of strategic planning for INCBA on our board of directors, and we would be lost without her. I feel incredibly lucky to count her as a close friend. Thank you, Amber, for joining. Shane Pennington is a partner with the law firm Porter, Wright, Morris, and Arthur, where he counsels clients on regulatory issues involving a number of industries, including energy, pharmaceuticals, controlled substances, aviation, and agriculture. Shane is a former law clerk to 3 federal judges on the DC Circuit, the 5th Circuit, and the DC District Court. He's an expert in administrative law and is regularly, he was called to the cannabis industry when he was introduced to Dr. Sue Sisley, an Arizona physician who was seeking to obtain a cannabis research license. And he ultimately helped her to successfully sue the DEA, first to obtain a secret DOJ Office of Legal Counsel memo, barring DEA from processing medical research applications under the CSA until it brought its regulations in line with federal law and United States treaty obligations, something that we'll definitely be talking about today. And then to require the DEA to process clinical research applications after years of delay. Shane has been a near constant presence in INCBA almost ever since, and I will take at least partial credit for that. A number of years back, Nicole Howell had put together a symposium in San Francisco on cannabis law, and Shane spoke about his work with Dr. Sisley and had all of us on the edges of our seats. And there were a group of us, I can't remember all of them, but at least myself, Katie Young, Mary Shapiro, basically kidnapped Shane at lunch and didn't let him leave the table until he had promised to join the organization. Since then, he's served on our board of directors and currently co-chairs our amicus committee. Thanks again, Shane, for joining. Finally, last but not least at all, Khurshid Khoja. Khurshid is the founder and managing partner of Greenbridge Corporate Counsel, which he founded in 2012, long before it even occurred to about 90% of today's cannabis bar that practicing commercial cannabis law was something one could even do. Khurshid advises cannabis businesses on issues ranging from licensing to corporate governance to M&A to, most notably for our present purposes, compliance with local and state and federal laws and regulations applicable to cannabis and hemp, including under the CSA and the Federal Food, Drug, and Cosmetic Act. Khurshid has been at the front line of the cannabis legalization movement for more than a decade. He helped to shepherd legalization in California. He has served as the president of the board of directors for the National Cannabis Industry Association and as a board member for the Minority Cannabis Business Association. Khurshid is also among the longest tenured members of INCBA. He was one of our original members, and indeed, way back in 2015, Khurshid presented what we think was INCBA's very first CLE presentation. And Khurshid is truly one of a handful of attorneys that's serving in this industry, upon whose shoulders the rest of us stand. So thank you for joining, and I'm beyond excited to talk to you all about today's topic. And Khurshid, we'll start with you. As far as you know, has anyone in the cannabis industry actually seen this letter yet?
No one that I know, but we heard rumors that the letter may not specifically refer to Schedule 3. Whether that holds to be true or not, we'll see. But no one that I know has seen it yet.
But if there are rumors about what it says, presumably somebody has seen it?
Presumably somebody has seen it, and I won't speak to where the rumors are coming from, but that gives me, I wouldn't mention it if I didn't think there was something to it potentially.
And Amber, am I correct in suggesting here that this is a pretty big deal?
Yeah, I mean, it's a big deal. This would truly, I mean, if you're looking, prohibition is rooted in racism, but it is also rooted in stigma. And so if we are having the federal government take a step away from the position that this is a terribly dangerous drug that will have everybody strung out, and really continuing with that fear narrative around cannabis, and if we're stepping away from that into a space now where we can just look at cannabis and what is maintaining prohibition without that overarching justification that really kind of provides cover right now for Congress to continue to not act on it. So to have a president like Biden, who is not, he's not the one that inhaled or even didn't inhale. He's an anti-weed guy. To have him taking an action like this again is, even without all the speculation about how this will happen, it's hugely impactful, hugely impactful.
And so I'd love to sort of poll the panelists on this question then, because as I mentioned up front, there's been a fair amount of disagreement about whether this recommendation, assuming that it is the recommendation we think it is, should be cheered or mourned. And so just real quick, on a scale of 1 to 10, 1 being despair, 10 being jubilation, where do all of you guys sit as far as, when you heard this news on Wednesday, the 30th of August, I think, what was your level of excitement, enthusiasm, despair around this? Amber?
So I was excited again, for the reasons I just mentioned. This means that something is happening. And the reality is Congress isn't going to take action under the current status quo that we have at the federal government. It really does provide them cover to maintain their inaction.
I'm going to push you for a number.
So how excited from 1 to 10?
Yeah.
How excited? It's the federal government. So maybe like 5.5.
Khurshid, how about you?
That's really high, considering that that's tempered with the fact that they can mess anything up.
True. Very, very true. I guess I am surprisingly a little bit more optimistic, and I would probably gauge my reaction at about a 7.
All right, Shane, how about you?
8.5.
8.5. All right. We've got very specific panelists here. All right. So this news is part of a larger process. Before we go on to discuss what exactly it all means, and how it impacts the industry, want to take a step back and figure out where exactly we are in the process that's unfolding and what comes next from here. Khurshid, can you explain why HHS is making a recommendation regarding cannabis scheduling in the first place?
Sure. So, this is in response to President Biden's statement on October 6, 2022, right, where he pardoned anyone who was still dealing with federal charges for possession of cannabis, urged the state governors to do the same for state level charges, and then called on the HHS secretary to revisit the scheduling designation for cannabis. And so that's where the initial impetus came from for this.
And Shane, I understand that we're seeing a Yeti here.
I'm glad I have a loyal reader. Yeah, so what you're referencing there is that this process that we're in, this administrative process, is an extremely rare one in federal law. In the 70s, when the CSA was enacted, it was a lot more common. It's called formal rulemaking under the Administrative Procedure Act, as opposed to what some people are more familiar with, which is informal rulemaking, which is like notice and comment. So notice and comment is part of the process here. But as we're about to find, this formal rulemaking is much more involved. So basically, at a very high level, the way that it works is, DEA gets a request or decides to sort of look into initiating this process. It then requests HHS's scientific and medical evaluation and scheduling recommendation. Once it receives that, it then does its own assessment based on a number of statutory factors, and it either decides to initiate the process or not based on whether there's substantial evidence to do so. If there is, it initiates the process by publishing a proposed rule in the Federal Register. So notice right now where we are is at that point where HHS has made its recommendation. DEA will now decide whether there's substantial evidence. If it decides there is, it will propose a rule. Now that proposed rule in the Federal Register will kick off a public participation period, which will include usually 60 days of public comment. So anybody can submit comments on the proposed rule. And then also interested parties can request administrative law judge hearings. Those are quasi-judicial hearings before a DEA administrative law judge. They're basically like little mini trials, and you can submit evidence, you can raise objections. DEA is then required to consider the comments. Eventually the ALJ will send a record of any hearings that are completed to the administrator. DEA has to respond to significant comments. Significant comments are those that, if taken, if found persuasive, would require a change in the rule. And then after all of that consideration and all of that data is in, the administrator will eventually issue a final rule, which will address the comments, the significant ones, resolve any lingering questions from the ALJ hearings, and decide what happens to cannabis. Does it stay in Schedule 1, or does it move to another schedule, and explain the reasoning for that. Then there's a 30-day judicial review period where any party aggrieved by that final rule can go to the DC Circuit or the Federal Circuit where they reside. Basically, I think it's principal place of business, but basically where you reside, and you can challenge the rule. And after judicial review, we'll have a new world for cannabis, maybe.
So it sounds like a best case scenario that tax break everybody's talking about is still a little ways off.
I think that's safe to say. And how far off and so forth is a very difficult question to answer with any specificity.
And Amber,
Jason.
Oh, go ahead, Khurshid.
Meant tax equity as opposed to tax break, right? Because we're paying a gross receipts tax that no other industry is paying currently. So
thank you for the clarification there.
I appreciate that clarification.
Yeah, no dispute. So Amber, there are specific criteria under the CSA that govern the scheduling process, right? What did HHS need to conclude in order to support a recommendation that cannabis be moved to Schedule 3?
Well, the overall criteria they have to consider is that instead of being like on Schedule 1, it's high potential for abuse, no accepted medical use. They would need to determine, or they needed to determine, that an intermediate potential of use, and there is some kind of medical benefit or medical use for cannabis. So there are 8 factors that they consider in getting there. And it includes actual or relative potential for abuse, risk to public health, variety of factors. When it goes to DEA, that changes a little because the realm of what they're going to consider is going to expand a bit.
And Shane, could HHS have justified a recommendation that cannabis be descheduled altogether?
It could have. To find that cannabis should be descheduled altogether, it would have had to have concluded that cannabis's relative potential for abuse is lower than substances in Schedule 5. Essentially, there are other ways under the text, but they've never been used. But that's what it would have had to have concluded. Now, whether it could have, how it would have justified that conclusion, as you move more and more dramatic in change, from 3 to 4 to 5 to descheduling, the amount of explanation that HHS would be required to give and then DEA would be required to give kind of increases, because under the Administrative Procedure Act, agencies can't just do whatever they want. They have to give a reasoned explanation, and courts will, review their explanation very carefully, deferentially, but carefully. And among the things they have to do is they have to contend with their past precedent. So with cannabis, you have basically, 50 some years of unbroken, uniform, multi-agency precedent, going all the way back before DEA was even an agency, saying that it has this high potential for abuse and no currently accepted medical use. And so actually what HHS did here, it had to conclude that in order to get out of Schedule 1 to move to recommend Schedule 3, it had to conclude that cannabis has a currently accepted medical use and treatment in the United States, and it had to do so. The only ways to do that before to make that recommendation were either to get FDA approval under the Food, Drug, and Cosmetic Act for interstate marketing as a drug, which for cannabis, for a number of reasons, would be impossible, both at this point and probably ever. Or you could meet a 5-part DEA test that DEA made up that's actually even harder to satisfy than the FDA approval for interstate marketing as a drug. And so because cannabis wasn't going to do either of those, and those were the only two paths that have ever been used before, in order to make this recommendation, HHS had to break new ground and find that there was a new way to satisfy the currently accepted medical use requirement. Presumably it did that based on the widespread acceptance of cannabis as medicine under state law, and doctors recommending it in treatment to patients as medicine across the country. That makes eminent sense, I think, and it, in fact, to deny that that's currently accepted medical use, I think is very problematic. However, it must be said that HHS is breaking new ground in saying that. Now, it had referenced that possibility in the 80s as a one possible way to get currently accepted medical use without FDA approval for marketing, but it had never actually applied it. So that's a really big deal. And the other thing it had to do was find that cannabis has an abuse potential less than substances in Schedule 1 and 2, which also requires reckoning with some of its precedent. And so to do that, it's going to have to give an explanation for why it thinks that old precedent, that old standard, isn't appropriate anymore, and a new standard is in fact the one that's more appropriate. That's definitely possible, and I think all of us here could probably do a decent job of explaining why that is reasonable. But as you go further down the schedules and you start to get towards Schedule 5 and descheduling, it's not that it's impossible. It's just that it becomes increasingly difficult to make that explanation work, because on top of having to contend with all the precedent that's out there, you also have to remember that the agency's making this new policy that will then apply to all substances, not just cannabis. So in future proceedings, they're going to have to now apply this new standard, and so they either have to make it very limited, if they're going to do something very dramatic, or they have to be ready to apply it to the next substance that comes down the pipe. So
it sounds like it'd be really useful to actually have this letter. And Khurshid, one of the questions in the chat here is, will INCBA make a FOIA request for the letter? Thanks to longtime member Joshua Mandel for that question. Khurshid or Amber, are you aware of anyone who's already sent a FOIA request for the letter?
I would be shocked if someone hasn't. I'd be truly shocked if somebody hasn't, but I have a feeling that by the time that person gets a response, or that organization gets a response, that they'll be releasing the letter anyways, because I have a feeling that's something they would like to come out in their own time. But again, I would be shocked if plenty of people haven't requested it already.
Yeah,
I know people have requested it.
Okay.
Yeah. No, not surprised.
And so there have been times since I've gotten involved in cannabis where the entire cannabis bar starts to think and speak en masse about a particular subject matter, and I think we're headed towards one of those moments with the UN Single Convention. And Shane, you've been thinking, writing, and speaking about the nuances of the UN Single Convention on Narcotic Drugs for years. Can you explain what it is and how it factors into the scheduling determination that we're looking at right now?
Sure. So the United Nations Single Convention on Narcotic Drugs of 1961 is a multilateral treaty that the U.S. is party to. It basically has its own scheduling system that is, somewhat similar, but still different in certain important ways from, what you see under the Controlled Substances Act under U.S. law. Basically, cannabis is in Schedule 1 of the Single Conventions list, which is sort of the second strictest listing that you could have. You could also be in Schedule 1 and Schedule 4, which is like the strictest possible under the Single Convention. That used to be where cannabis was. Recently, it was moved out of Schedule 4, so it's just in Schedule 1, still very strict. And there are all sorts of requirements that the treaties impose on signatory countries. Importantly, though, the treaty is not self-executing, which means even once a country signs the treaty, it doesn't become part of their domestic law until they pass a statute or some other form, whatever their, we pass statutes, whatever way you make domestic law in your country, you have to execute that treaty as a matter of domestic law. In 1971, the United States made the single convention binding for purposes of domestic law to an extent, by passing the Controlled Substances Act, and in particular 21 USC 811 D1. And that provision says that, all this big process that I explained earlier, this formal rulemaking process where HHS and DEA all weigh in on scheduling decisions, that whole process doesn't apply when a substance is listed and controlled under the single convention. Where that's the case, the statute says that the Attorney General shall place the substance in the schedule that he deems most appropriate to carry out U.S. treaty obligations under the single convention. Okay, now you might ask, well, why are we doing this entire thing if all of this rigmarole, this formal rulemaking process just doesn't matter and DEA is just going to put it in the schedule?
I was just going to ask that.
Right. Yeah. So there are a couple of reasons. One is because it's possible that agencies will get it wrong. And when they get it wrong, they need to have an administrative record. And, that administrative record, if they just did the treaty part and didn't do the rest, then if it turned out they were wrong about that, we would have to go all the way back and do everything again. It would slow the whole process down. That's the first reason. The second reason is that in the 70s, courts dealt with this and basically said that the way that it should work is you should do this whole process and DEA should figure out what's appropriate for treaty compliance, but then within that range, whatever the limit is that the treaty will bear, right? Within that range, DEA should still pay attention to HHS's recommendations. And so that's the sort of second reason that they do it. The third reason, and perhaps most important, developed later, actually pretty recently with Epidiolex. And what we've seen, actually, I think this happened earlier too in the 90s with Marinol. In any case, what happens is DEA can put a substance in, say, Schedule 3 and then impose other regulations to ensure treaty compliance. So it doesn't have to put it in a schedule that by itself will ensure treaty compliance. So let me unpack that just a little bit. Schedule 1 or 2, DEA has said historically will ensure treaty compliance on its own, right? Just placing a substance there ensures it because Schedules 1 and 2 have all of these reporting requirements, import-export requirements, quota requirements that are part of the treaty compliance landscape, okay? With Epidiolex, when FDA approved it, DEA was like, okay, well, it can't be in Schedule 1 anymore as marijuana, so it has to be moved out, but where should it move? And they decided to move it to Schedule 5 and then impose those treaty-related requirements independently through regulation on Epidiolex. So they made sort of a bespoke scheduling for Epidiolex. Later in the 2018 Farm Bill, Congress removed hemp from marijuana, and after that, DEA just took Epidiolex off the schedules entirely. But the reason that it's important is because this shows that you can go to Schedule 3 and still comply with the treaties, basically.
Wonderful. All right. So
If I could just
go for it, Khurshid.
Yeah, so I think that the main takeaway though for me from that is that the DEA has ways to basically say, hey, we're not going to follow the HHS recommendation.
Absolutely.
Right? They may not avail themselves of the flexibility that they potentially have to reschedule and still comply with the treaty and just say, sorry, it's Schedule 2 or that's the best we can do. And still comply. So they've got reasons to say no, and they've got justifications, statutory justifications to say no, right? They also, I think it's also worth highlighting again that the DEA, while it's going to consider what HHS says, they do have to have their own assessment of whether or not there is currently accepted medical use, and that's where that 5-factor test comes in, right? And those 5 factors are very closely related to what the FDA would require for a new drug application, right? To get a new drug approved, right? Not whether or not something is a quote unquote drug under the FDCA, but whether or not it can be approved as a pharmaceutical product for medical indication and marketed that way, right? So that 5-factor test is still significant because there haven't been any whole plant products really that have gone through successfully and received new drug approval, right? We've got single molecule drugs that have done that, but nothing close to what we have, available on the state market.
So this is going to bring us to our second poll of the day. Schedule numbers only, because we are, time is short and we have lots of questions coming in. What do you think, each of you, the DEA scheduling determination will be? Shane?
3.
Khurshid?
2.
Amber?
3.
All right. I'm looking at the questions. If you see my eyes going off, I'm trying to follow the Q&A because we've got a lot to go through here. And as questions come in that are relevant to what we're discussing, I think it'll be good to just drop them in.
Jason, do you mind if I follow up on some important points that Khurshid made? I'm happy.
Not at all.
Okay, I'll try to be as fast as possible. First, he's right that this is a way that DEA could block it. That's why Matt Zorn and I wrote a law review article explaining that 21 USC 811D is unconstitutional. I can go into why. It's probably unconstitutional for multiple reasons. We wrote about the private non-delegation doctrine. If DEA were to invoke the treaty to block this historic progress for cannabis, obviously we would be looking for a client to pursue litigation to raise that theory, among others, to make the world
Don't
right
go
again.
into it now, but what I can promise folks is that Shane's going to give me a link to the law review article, and we are going to send you guys all the registrants for today's event. We're going to send you links to materials. We have one of our generous sponsors, Cannabis News Hub, has actually put together a cultivated list of relevant articles, and we will send you that, as well as any links that the panelists would like for participants to have as well.
The second thing is very short, but I think important, which, Khurshid made the point that, listen, that 5-part test, DEA could also, invoke that, say cannabis hasn't been approved by FDA for interstate marketing. It doesn't meet our 5-part test. Therefore, we have to keep it in Schedule 1, or I guess, Khurshid thinks they're going to find currently accepted medical use if he believes we're going to Schedule 2. So, but in any event, if they did invoke that, that the problem there would be that since HHS has said that it believes that cannabis has a currently accepted medical use and treatment in the United States, that determination is very likely binding on DEA because it's a scientific or medical determination, which under 21 USC 811B, Congress made binding on DEA through the process. So my view is that without the treaty, okay, it would be very, very difficult and probably just impossible for DEA to go anywhere but Schedule 3 or better at this point.
Thank you for that. And as I said, I want to drop some questions in here that are coming in. We have one coming in from Nicole Stanton. And Nicole, thanks for joining. Has there ever been a case where something was recommended for rescheduling and then through court challenges ends up being unrescheduled? Do you know what happens in the meantime during the challenge? Does it stay Schedule 1 or Schedule 3, or until all challenges are resolved, does any change not go into effect?
Who is that question for?
I think it's a question for the panel. Anybody who would like to answer.
So first of all, in the history of the CSA, I'm not aware of any time that DEA has overridden an HHS scheduling recommendation for any reason other than the treaties. Okay. It has told HHS very politely, sort of asked, would you please reconsider? I know it did that with Kratom. It may have done it another time. I'm not positive. But I also, this isn't just like me having perused the Federal Register for this. In 2017, Matt Straight, the chief policy advisor of DEA at the time, testified before Congress that, in fact, he was not aware of DEA ever having overridden an HHS scheduling recommendation. Okay, so now about judicial review. The way that this will work is that once DEA puts a final rule in the Federal Register, the effective date of that final rule will be delayed for 30 days. Then when there's judicial review, a court could put a stay on the final rule, effectively preserving the status quo during the pendency of litigation. Depending on what circuit you're in and the law that applies, that will change the standard that would apply. But in general, the way that injunctions work in judicial review of administrative proceedings, usually the person who's asking for the stay, which would here be the person who's opposing the final rule, or the party, that party would have to show some sort of irreparable harm from the change. So they, there will immediately be, once there's litigation, there will be, one side arguing, I will be irreparably harmed if this isn't stayed. And then the other side will be saying, no, you will not be. And, depending on how that cuts, the court could stay the effective date of the final rule through the pendency of litigation, which can take, sometimes quite a while, up to, 2 years, possibly. And so then, after all that's wound up, then, you either, if the final rule is upheld, then you would eventually get the effective date then, and then the effects of the rule would be real and start to affect the law in the United States.
Amber, don't politics play a role here? Ann Milgram is a Biden political appointee, right? How likely is it that DEA is going to undercut the Biden administration's attempts to make progress in the world of cannabis?
Politics is always at play in everything. But here in particular, I don't believe that they would have undertaken this process and gotten this far without having a level of agreement across agencies. And so I think it's also important to remember that this isn't just DEA in isolation. This is DOJ with a few other even higher ranking political appointees that have all tended towards being far more progressive when it comes to criminal justice reform and drug reform, obviously, than DEA. FDA is even more progressive when it comes to drug reform than DEA. So again, you're looking at a lot of political appointees and an administration that, despite having a president who does not like cannabis, has outwardly committed to looking at the decisions that the administration makes and that the agencies make through a lens of equity. This is part of a series of executive orders that the president put out. So again, I think you're working again with a theme that would make this politically challenging for the Biden administration if DEA were to go a different direction. And so therefore, I strongly believe this is something that has likely been sorted out before getting this far. They have been working on this for a very long time. The agencies have all been talking. It isn't as if HHS was hiding out in a room looking at their stuff and then boom, sprung this on DEA. They have been in conversations since the president actually put out his directive.
Thanks for that. And Amber, I'll go back to you as well, because you and I have talked a bit about the amount of federal agency rulemaking, even outside of the process that we're talking about here, that a move to Schedule 3 would mean. Can you talk a bit about that?
Yeah, so I mean, I think one thing where I think a lot of the confusion comes from around this conversation is what you could do in the rules here, and then what actually is going to require passing law to implement. So even if you take out all of the things that are going to require changes in law, so things like criminal justice penalties, things like immigration, housing, the scholar of financial aid issues. So those are things that are going to require rulemaking. But DEA itself has regulations that it uses to implement the CSA. Those will all have to be promulgated. And then I don't foresee FDA undertaking rulemaking. I do see them aggressively undertaking guidance making, meaning that laying out their opinions and views on what this means in the context. I don't see, again, there being a change in the framework at FDA really based solely on the move to Schedule 3. There will be a ton of policy development. And, really the bulk of what agencies do, especially FDA, they don't like to actually do a rulemaking. They just like to get you with their guidance. And so I see that being a really kind of aggressive process that is going to be undertaken really before we have a law in place that is going to give us a really clear idea of where the agencies are headed based on what we're looking at with Schedule 3 potentially.
And we've got a follow-up on your previous answer. There's a question from Harry Bernstein. Do you think that TTB and Treasury have been involved in the the various agency and administration discussions that that you referenced?
From what I have heard, to a far lesser extent, they are not part of this conversation. From what I am hearing out of the administration, this is truly industry. This isn't about industry. This is about looking at the evidence, looking at the scientific and medical data that they have, and then making the administrative decision based on that. This isn't about industry and about future regulation. TTB has been sort of recognizing that they need to prepare in the conversations I've had with them, recognizing they need to prepare for the eventuality. But again, for TTB to become a factor in all of this would require change in the law. And so not just removal from the schedule, but it would actually require setting up a framework for them to actually come in and play a role in the regulation of cannabis.
All right. So we've gotten through at least a scratch the surface level discussion of where we are in this process and what comes next. Let's go on to what I think folks are paid the price of admission to really hear you guys talk about, which is what the hell does this all mean in practical reality for the industry, for the cannabis legalization movement. So let's dive into that. Amber, how confident are we that we're getting the tax equity that is being discussed widely if Schedule 3 becomes a reality?
If Schedule 3 happens, I believe we get the tax equity because unlike a lot of the other areas that are affected, this is really 280E is explicit when it comes to 1 and 2. So we get the tax equity. That doesn't mean that Congress doesn't come on the tail end of that or even run ahead of it and say, okay, but we're going to hit you with an excise tax. It doesn't mean that we'll have, they could find a way to make up the slack, but in terms of ending 280E, if we do get to Schedule 3, I believe we actually finally get relief from that.
Speak up if anybody disagrees, but I think there's uniformity on that. So let's go on to a topic that a number of folks have asked about, both outside of this context and in our Q&A. And Khurshid, I'll say, in preparation for this, I've read a lot of the writing that you've done on likely impacts for rescheduling. And one of the things that stood out to me was that while criminal penalties for violations of Schedule 3 are less severe than those imposed under Schedule 1, typically, rescheduling would actually have limited impact on cannabis-related criminal penalties. Can you explain why that is?
Yeah, so, but before diving into that, I just want to remind folks that marijuana and THC are both scheduled individually under Schedule 1 currently. And so we don't really know what the HHS recommendation, whether it's going to extend to both marijuana and THC or not, but that's an open point. But within that vein, right, as you noted, the criminal penalties for Schedule 1 and Schedule 3 are different, but rescheduling marijuana to Schedule 3 would not affect criminal penalties right away because those penalties are set forth in the CSA separate and apart from the penalties for Schedule 1 substances, Schedule 2 substances, Schedule 3 substances generally, right? There are specific provisions that say, hey, if you have 1,000 pounds or more of marijuana, you get this. If you have 100 pounds or more, you get this. If you have 50 pounds or more, you get this. But they're all carved out of the schedule-specific penalties under the Controlled Substances Act. Now, THC, and specifically synthetic THC that's not derived from a plant source, would not fall within those penalties for marijuana, again, because it is separately scheduled. And so if THC and specifically synthetic THC is also included within the recommendation, within the rescheduling, then with respect to at least, if you are facing criminal penalties for synthetic THC, then yes, arguably this would reduce those penalties, right? But for marijuana itself, the plant, no, not on its own. At least we would need to have other work done. Presumably Congress would need to act to actually amend the CSA in that respect, right? The other thing to keep in mind is that, and we'll talk about this in a bit, but to the extent that we have other agencies now enforcing other federal laws against cannabis, specifically the Food and Drug Administration enforcing the Food, Drug, and Cosmetic Act, there are criminal penalties under that statute as well. And so if you're found to violate that statute, you are potentially facing criminal penalties there. And so you could, have penalties under both the CSA and the FDCA if there's rescheduling, right? So again, I know we'll talk about it, we'll get into it, but that's something I wanted to note as well.
Wonderful. And Shane, notwithstanding, some of what Khurshid just laid out, could rescheduling to Schedule 3 potentially impact criminal charging or sentencing decisions in less formal ways?
Yeah, sure. So just to follow up pick up where Khurshid left off, it's true that the FDCA is enforceable through DOJ action with criminal penalties. It's also, that would also be true if cannabis were descheduled, and it remains true with cannabis in Schedule 1. And in fact, you would think that there would be a much higher priority and sort of license for FDA to go after cannabis companies if it had the interest in doing so with cannabis in Schedule 1. It would be extremely odd to relax the standards that apply at the federal level for the first time in history as a way to sort of signal the dawn of a new day of strict cannabis enforcement from these agencies. It would be even more surprising if they had the billions of dollars of resources and manpower laying around that they haven't already been wanting to use while it's in Schedule 1, and now that it's in Schedule 3, they decide, oh, here's all this, let's go after it now. But if they wanted to, they could also do that if cannabis were descheduled. So I think that's it's just a risk. I mean, enforcement is a risk. It certainly is. It's a huge risk today with cannabis in Schedule 1. It will remain a risk when cannabis is in Schedule 3. It will not be a risk for the IRS with respect to the IRS and 280E. We know that, right? So there are, these are complicated questions that persist across the spectrum of scheduling to descheduling, right? And then, your specific question about informal ways. Yes, there could be indirect effects. No one knows what they might be, but you would certainly understand that in general, a prosecutor or a sentencing judge facing, looking at someone who's charged with a drug-related crime under the Controlled Substances Act is, in general, all things being equal, going to perceive, rightly so, Schedule 1 related violation as more troubling than a Schedule 3, Schedule 5 related, violation. And so they can make discretionary choices about what they charge, whom they charge, what sentences they recommend, what sentences they impose in the case of a judge. And I think another thing that's important to note that, folks sort of on the other side of this conversation don't emphasize for reasons I don't really understand, but the thing I'm concerned about is a backlash among the prohibitionist states, right? So the more dramatic the change for cannabis, sort of a pro-cannabis reform change, right, to Schedule 3, Schedule 5, descheduling, as you go up the ladder towards, like sort of full rational reform that I think all of us want, the higher the likelihood, I think, that there's a backlash among cannabis's enemies at the state level. And we all know that the state level penalties and the state level regimes are the ones that have historically put the most people in jail for cannabis related violations. And so I think that this is just an incredibly complex question. And I think what we can all agree on is that no matter where cannabis lands after this process, we need to work together this is just the start. I mean, there's so much work to do on criminal justice reform, sentencing reform, on, tax reform, immigration reform, you name it. I mean, we are a long way from the promised land. I don't think anybody questions that. And so, but beyond that, the talk of what would happen, depends a lot on politics, enforcement discretion, and the part that I think people often overlook is resources. It costs a lot to ramp up enforcement on a multi-billion-dollar nationwide industry that you've been categorically ignoring for about 50 years. That is a big ask. And that's why I think you saw with CBD, for example, when it was, descheduled effectively through the 2018 Farm Bill, you didn't see FDA chomping at the bit to go run after FDA, all the CBD companies. It sent a few warning letters to those who were, making medical claims in interstate commerce. But there has been
I want to,
or would there really likely be?
I do want to put a pause on the question of likelihood of enforcement, because I think it's something that we'll get into more inherently as we talk about, exactly in a nuanced way what impacts this has on how cannabis is regulated at the federal level, and what agencies are involved in that. I want to move on to the next sort of bucket of issues about how this move would practically impact the current status quo and talk about research implications. Khurshid, you've worked on obtaining Schedule I licenses for clients participating in cannabis research. How would rescheduling cannabis from Schedule I to Schedules 3, 4, or 5 facilitate medical research?
Sure, happy to address that. I am biting my tongue because I had a number of responses to what Shane just said that I will try to reserve for later. But suffice it to say, I think there are plenty of reasons to think that FDA may step up enforcement under the FDCA, and frankly, it only costs a postage stamp to sow fear in the industry, and enforcement doesn't just happen, via crackdowns. But I will leave it at that for a few minutes, and I will say that with respect to research, I'm grateful to kind of have my views evolved on this a bit, but Shane will discuss this as well. But the Medical Marijuana and Cannabidiol Research Expansion Act, kind of delivered a lot of the research-related benefits that were promised by rescheduling advocates, right? And so we got a lot of those benefits in December 2022. That being said, again, that act does not apply to non-plant derived THC, right? So, I have clients that are producing that at scale through biosynthesis for research and development applications, right? And so they would not be covered under that act. And so assuming that both marijuana and THC are dropped to Schedule 3, in that instance, that move would still benefit medical research using non-plant derived forms of THC. And
Shane, you've noted that the recent passage of the Medical Marijuana and Cannabidiol Research Expansion Act may actually mitigate the expansion of research that rescheduling to Schedule 3 would entail. Why is that?
Yeah, so I've written about this so folks can read it. Hopefully we're able to send out, and listen, I hope I'm wrong, because I would really like to say that it's going to help research. As your intro, my background, like that's why I got into all of this in the first place, was research. So I'm very much pro research. I think it's an absolute travesty that the federal government has kept us in a cannabis dark age for so long on just science. Science is pro science is pro public health as far as I'm concerned, and I can't believe that anyone in the federal government is still confused about that. But yeah, so the act that you're talking about, which I won't repeat the title of again, actually made cannabis research harder at the federal level, not easier. And if you want to, I can explain why and all the reasons, how that is. But perhaps the easiest one to appreciate, given our historical reasons for being here now, is that because cannabis, like those sentencing provisions that Khurshid was talking about earlier, that are cannabis specific and therefore don't hinge on cannabis's scheduling under the Controlled Substances Act, the Medical Marijuana Cannabidiol Research Expansion Act made similar cannabis-specific provisions for the research requirements that apply under 21 USC 823. So unlike other substances where the research restrictions hinge on scheduling, and when you get past Schedule 2, they get a lot easier and so forth and so on, that's no longer the case for cannabis. Now they're totally agnostic towards schedule, and they just apply to cannabis as cannabis. Okay.
We've created the same problem we have in the criminal penalty.
Yes, and just to be clear about this, and then on top of that, it actually imposed additional restrictions beyond the already crippling ones that existed before that bill was signed into law. And I was like railing and ranting and raving about this for months before the thing was passed. And then once it's passed, guess who comes out on the formerly known as Twitter platform and says, I drafted this, I'm celebrating this. It was none other than Kevin Sabet and Smart Approaches to Marijuana, the troll under the bridge of everything cannabis at the federal level. That was who wrote that. And the fact that we allowed that to get through is just an astonishing embarrassment. And it's something that's going to have to be undone. And what I hope that once we get Schedule 3, which I hope we get, people will realize what a, crap sandwich we have in this regard and others. And that, again, we don't stop the work that, we have begun, and we push forward for other reforms in this area as well.
So I'll thank you for, your efforts to keep the programming PG and, with the crab sandwich comment, but you did promise that you wouldn't say the name of the statute again, and you went and did it. So
I think I misstated it, though. Isn't it the cannabidiol and medical marijuana? I think so. I think I messed it up.
Fair enough. All right. So we are now going to move to, formally to the topic that I think there's been the most interest in getting into as we've gone here, which is federal agency oversight of cannabis under Schedule 3. Amber, what implications would this move have on cannabis oversight at the federal level? Would moving cannabis from Schedule 1 to Schedule 3 mean that the primary agency responsible for federal cannabis law would shift from DEA to FDA? Help us out here.
So I want to preface this with the fact that there is no path towards legalization in which FDA is going to be a friendly agency into which the existing cannabis market will fit. So there is no universe in which the industry as we know it now and the range of products we have now will be comfortably regulated under FDA. It has never been a fit. It never will be a fit. So going back to the original question, DEA still has enforcement authority over the CSA. FDA doesn't get any new authority. It just has authority over drug safety. What you will likely see, though, is now kind of what we have seen with kind of hemp and CBD. We're not seeing a big crush of enforcement down on the hemp and CBD industry. What we are seeing, and the biggest primary argument, is when FDA is saying that these companies and these products and their claims are infringing into an area that is drug territory. So products making drug claims, something else to consider is products that include ingredients that are moved in interstate commerce in these products. So if you are selling a dangerous ingredient, anything that's going to infringe on, or if you're marketing something as a dietary supplement. So again, I think what enforcement looks like will very much track what we are seeing with CBD and hemp. There is no new authority that is automatically granted to FDA. In fact, FDA will be extraordinarily resistant to anything that disrupts their current framework. They want everything that they do to fit into the framework that they have there. So we're not going to see, without an act of Congress, we're not going to see a major shift in, it isn't like we wake up one day and now all of a sudden DEA is done and we are being regulated by FDA. DEA will still be looking at diversion and other issues concerning safety. And we're going to talk a little bit later about some of the other concerns I have with DEA's findings. But yeah, there isn't a magic button that switches on and then all of a sudden this is an FDA problem. FDA has been very clear that it doesn't regulate, it's not trying to regulate state cannabis products, especially ones that are sold in the adult use market. This isn't their thing.
And just to be clear, a lot of the areas for enforcement priority that you laid out there are things that, you know, INCBA members have been, you know, imploring their clients not to do for years, right?
I have tried through interpretive dance, screaming, pleading, memos. Please don't market your products using like a brand name candy label. Please don't make drug claims. Let's not talk about cancer here. Let's not, you know, be mindful of things that are attractive to children. So these are all things that we should be doing already. We shouldn't be selling products that are dangerous to people. We shouldn't be marketing products as a product that they are not really making consumers believe that they are seeing, you know, that they are, you know, getting a dietary supplement when they're actually getting weed. So again, I think these are all types of enforcement that we're seeing already, but they're to depart from that and to then put themselves in a position where they're using the FDCA to then start kind of reactivating, you know, a level of enforcement priority that doesn't track with what the rest of the federal government wants to do. They just don't have the resources to do it, and they are not going to have the political will to do it. So again, I don't see the immediate giant, oh my gosh, then it's going to be a crush and they're going to move to crush the entire state regulated market. There is going to be an increase in enforcement because some of the really ridiculous and egregious things that go on in the space will be part of this, what FDA will flag and will address.
And so, you know, Khurshid, I want to give you please 1 minute to respond to what Amber said and add anything to that you'd like to.
I'll do my best. So, you know, I also want to respond to some of the things that Shane mentioned earlier, but
Sure.
Amber's right. You know, and Shane's right in that the FDCA applies now. It applies in the event of rescheduling. It applies in the event of descheduling, right? And so that problem of, hey, the FDCA applies, and this is how they've applied it, you know, when hemp was descheduled, right? That is a problem that it's not going to go away, right? And we need to address it head on. You know, I've heard, you know, before, hey, the FDA has no interest in this. Fantastic. Let's just put it in writing then. That's all I'm asking is let's get, you know, let's ensure that we have this carve out so that the FDA is not using the same playbook on state level cannabis products as it has on descheduled hemp products, right? So I think that is to kind of say, hey, the FDA is not going to do anything when we've seen them act as they have with respect to hemp CBD products and now also hemp THC products, right? THC8 products. It belies this sort of, you know, hey, the FDA is not going to do anything. It doesn't, they don't have to go in and bust heads. They don't have to go in and seize products. All they have to do is send letters, right? And they know everyone's license number. They can get that from the state. And, you know, presumably they will coordinate all this with the state before anything like that were to transpire. But, you know, black letter law is still black letter law. And that is the playbook that they have right now.
I definitely want to underscore that I definitely didn't say they were going to do nothing. They will absolutely increase enforcement, but it is likely going to be within the realm of what they consider priorities. Because when outside of drugs or food, they have a pretty limited range of things that will spur them to act. And I do want to clarify that what you were saying, that clarification that we would need, that FDA isn't going to act a fool, is one that has to come from Congress. And I think that's part of where this conversation around rescheduling is getting muddled, not by you, but generally the broader conversation is because I wholeheartedly agree. We need that ASAP, even hopefully before, but that is something that has to come from Congress.
And I think that Shane, I'm going to give Shane a minute here because I know Shane, you've described. Sorry, go ahead, Khurshid.
So in terms of enforcement, priority, that appetite is going to grow. Traditionally, historically, there has been deference. The FDA has deferred to the DEA on Schedule I substances, right? And so that's why we see enforcement on hemp CBD products and Delta-8 hemp THC products. When you have a descheduling, the FDA says, all right, well, it's no longer politically, we're not really barred from, we're not going to step on anyone's toes by sending out our enforcement letters, right? So that's written up in detail in one of my, both of my my pieces on this. So I'll make sure that folks have that. But that's history, right? That has happened. We know that that's happened. It's happened with respect to other substances as well. LSD and MDMA also similarly were regulated by the FDA at a certain point before the CSA was passed or before a substance was scheduled, right?
All right. So that actually teases up perfectly for what I was going to ask Shane, because you've described some of the concerns around heightened FDA enforcement as one of the three horsemen of the legalization apocalypse. Can you tell us what you mean by that?
Yeah, I mean, I guess first, I just want to make sure that I feel like I got maybe more time than and I don't want to have an unfair conversation. So Khurshid, if you weren't finished, I'm happy to donate back some time here to you or Amber if you'd like to weigh in further.
I'm sure I'll have plenty to weigh in
Okay.
on.
Okay, cool. Yeah, I mean, look, I think I want to be clear about what I'm saying. It is possible that you could have a new administration come in and decide to ramp up enforcement, but they could also do that with cannabis in Schedule I. What I'm not fully appreciating, or if cannabis were descheduled, and in fact, if cannabis were descheduled, then the DEA wouldn't have jurisdiction over it as a controlled substance, which means the primary point-running agency in the federal government with control over cannabis would be the FDA, which would mean that when Chuck Grassley or others want to get answers about what's going on with this crazy cannabis out there, right? Who would they call? FDA. Who would have to answer for anything crazy that happens out there with respect to the federal government? It would be FDA. So if you're really serious about being concerned about FDA enforcement, which I am, then that doesn't mean you should be opposed to descheduling, but I do think it means that you should be taking Khurshid's very wise advice to see everything out there that could happen as more reason for us to get more engaged as a community. And we need to drop these petty differences that are going on in LinkedIn comment sections all the time and everywhere else at our meetings and all over the phone, and start coming together to try to work on these urgent problems sooner rather than later. And that would be true, is true if cannabis remains in Schedule I, certainly true if it goes to 3, would be potentially even more urgent if it were to be descheduled. I mean, to the extent you're concerned about, state prohibition and FDA enforcement.
Again, just on the Schedule I point, though, there has been documented deference from the FDA to the DEA. When things are Schedule I, they generally will not go in and enforce. And so that's why, it's not that rescheduling creates new authority for the FDCA. That's not the case, as we've all said, right? It's that the gloves are off in a sense, right? The political impropriety of trying to step on the DEA's toes, not there anymore because it's not Schedule I anymore. And again, that's what we've seen with other substances.
In speaking to the agency, I don't think it's about political propriety. I think it's about resources and authority. And then once they actually have authority here, they're still going to have very limited opportunity to do anything because, again, resources. And so again, this is where I see we are going to be tracking in a very similar way that we do to CBD and hemp products.
I mean, look, I just don't think we disagree that much, really. I mean, because I really don't. Because it's not as though anybody on this panel or anybody out there in the rational world is going to argue for Schedule I. Like, that's just not gonna, I don't think I need to really add to that. And so to the extent that you're concerned about incremental shifts anywhere else, most of those incremental problems that you would see would also be there if cannabis were descheduled. And in fact, some of them would increase in their urgency if cannabis were descheduled. Well, and I'm not trying to diminish. I mean, I'm for descheduling. If I could wave a magic wand, it would be descheduled through this administrative process, okay? I can't. So I'm just trying to say, if we're all in the same boat, wanting out of Schedule I, right, then really what we our disagreements are so minimal, because at the end of the day, even whoever's right about this enforcement discretion issue, how much there will be and whatever, it could change. I think we can all agree about that, with a new administration, or somebody, gets a bee in their bonnet about something, whatever, right? And in any event, what we need to be doing as an industry and a reform movement is working hard to make the changes necessary to have rational reform, regardless of what administration is, occupying the Oval Office, et cetera, et cetera. And that's what I think is the important work that we should all join hands and, roll up our sleeves and get to work on.
So if you want to help, all three of these folks will put their emails in the in the chat, and copy all of them, and let's get together and work on this. All of the talk of regulation enforcement, of course, gets to what's the practical impact of rescheduling going to be on current state licensed commercial cannabis businesses? Amber, these businesses currently operate in almost complete disregard of federal law, right? Assuming their operations don't change, would they be any less illegal under Schedule 3?
They will be no less illegal. So yes, they will not technically be any less illegal, but I do believe, again, that when we were looking foundationally at what this says about cannabis in general, and the level of fear, and the justification for fear and resistance to this idea that it really supports, starts to disintegrate. So still absolutely illegal. Let me say that a few times, little highlight and disclaimer. Still absolutely just illegal. But again, I do believe that this creates shifts. The potential impacts of 280E going away, again, a lot of the impacts we're just speculating because we haven't seen the letter. And so to truly understand the breadth of impacts, we have to see the letter. But just again, if we're speculating about 280E going away, it's not just the tax. I mean, the flowing of money in the industry, what that would do for potential opportunities for investment, both flowing out of the cannabis industry and then flowing into the cannabis industry, would change dramatically.
And I want to put a question to you on that one, because we have a question in the chat on the 280E and with tax equity in quotes from Calico Castile, who we all know and love, the president of the Minority Cannabis Business Association. He says, to the tax equity point, isn't realistically large MSOs with large marketing budgets will benefit from a 280E tax relief more than small businesses, because they'll be able to write off a whole lot more?
Well, they have more money. They make more money because they're bigger and make more money, so they're going to save more money. But if you're looking at it, I've represented both small independent and social equity operators, and I've represented larger companies. And so the larger companies have a multitude of ways to try and minimize their tax outlay, their total tax outlay. Small businesses don't have that. So if you're looking like proportionally the small versus the larger operators, this absolutely is way more impactful for small businesses that can't hire, that can't be, doing lease backs and operating multiple different business entities and, shifting operations and certain parts of their operations to this multi-state structure around the country. So again, there's really this multitude of ways that larger companies are able to, relative to the tax, the overall potential tax burden, get that down. Smaller companies don't have that, generally speaking. So again, I think the proportionality of this, so yes, the overall total amount that an MSO is going to pay is going to be less because they make a lot of money. But when it comes to, again, relative to what they're making, I actually think for smaller businesses, this has the potential to even further benefit them, at least from the tax perspective.
And
to touch Nico's point, though, I think we would be remiss if we didn't also factor in the fact that a lot of the big MSOs are publicly traded, right? Even if they're not on the major markets or on the Canadian markets, they are still publicly traded. And everybody in the investment space, in the retail investment space, and in the cannabis market is looking at this. And as you mentioned, Jason, immediately after the announcement, we saw green candles, right, on the on the star charts for a lot of these companies and a lot of the ETFs and other vehicles that are out there. And so, that's something that these small mom and pop businesses, equity businesses don't have. They don't capture that value. And so there is that important incentive that I think is worth.
Do you think it's possible that they capture that value in the form of increased access to capital more broadly, or do you think that's not a benefit that will flow to smaller companies?
I absolutely believe that. So first of all, I've come up with this, I've heard this argument a lot of times over the years. Something would benefit MSOs more. Is that a reason? If it still benefits the other group of people, is that a reason to not take action? Sometimes I think there are situations where that can be the case. Here I don't see that as the case, because it isn't just, again, when money starts flowing into the industry and these businesses actually become profitable, people will want to invest. We are never going to fix racism in this country. We are never going to make banks less racist in their lending. We can try and pass laws, but that is never going to be the case. So whatever we can do over time to try and fix that, that is fantastic. But trying to fix racism in a cannabis bill about lending or banking or anything to that effect is not realistic. That we just don't have the leverage to affect that kind of change. So again, I don't think that something potentially, yes, the capital markets thing will be way more beneficial to large companies, but it does actually open up. I mean, I've spoken to other ancillary, real estate investors, other kind of service providers that are now other banks and financial institutions that are like, hey, does this mean I'm going to be able to actually make money off this industry? And they are starting to turn their attentions towards the cannabis industry. So not all of that is just going to be exclusively capital markets.
But it's also true.
So I am down, just to be clear, to stay as long as you guys will and answer every question in the chat. But we got about 13 minutes left, and we got a couple of topics, like large topics, to get through. So I want to move on. And one of those things, and we're actually coming to you, Khurshid, because one of the constant questions that I've actually gotten about what the impact of a move to Schedule 3 is going to be are around interstate commerce and how it impacts interstate commerce. You've previously written that rescheduling to Schedule 3, shifting enforcement from responsibility from DEA to FDA, and applying the FDCA's existing drug provisions could permanently freeze access to interstate and international markets for current state licensed cannabis businesses. Can you unpack those concerns? And while you do, just to be clear, my understanding is what you're talking about there is cutting off access to federally legal interstate commerce.
That's right. I mean, but that, for state licensed operators, federally legal interstate commerce is really the only interstate commerce they can engage in and still hold on to their licenses currently, right? So, yes, they want a federally legal interstate commerce market in which to sell within, and anything less is not necessarily going to meet their demands and may even, have downstream repercussions. But that being said, I think, again, I want to highlight the fact that whether existing cannabis products can successfully navigate the NDA process is a completely separate query altogether from whether those products are actually being marketed and sold as unapproved new drugs, right? So, for instance, we've seen that the FDA has alleged that inhalable hemp cannabinoid products are drugs under the FDCA, and they've said so in their warning letters, even though those products might never be approved as a new drug, right? So, just want to make sure that that's clear in the background. As others have said, the industry, try as we might, we've tried to get our clients to not make medical claims, not make health claims, not do things that are going to run afoul of the FDCA. Has that stopped them? No, unfortunately, it has not stopped them. And so you see that as being pretty, rampant in the industry. And the very fact that we're talking about medical cannabis, right? Like, I mean, we're already talking about something that is marketed as a a medical good. And so I think the fact that we have this history of claims being made both about medical and even adult use cannabis claims that would cause these products to be deemed unapproved new drugs is problematic. It's a way for the FDA to say, hey, we have jurisdiction here, right? The other jurisdictional hook they have, interstate commerce, these products couldn't enter interstate commerce without violating FDCA prohibitions, right? And this is true across a whole range of products. And that is the basis, right? The fact that we have this history of claims, the fact that we, also, don't necessarily need interstate commerce for the FDA to step in. They can say, and I think Amber's highlighted this point as well, that, hey, you've got this edible product that you are marketing, and yes, you're only selling this in Maryland, but all your ingredients came from, across state lines, right? And so based on that, or based on the presence of diversion, based on the presence of out-of-state, consumers that are coming in to buy that, there is an interstate commerce hook, right? And so that's what I think is going to be problematic for folks who want to legally enter the interstate commerce, is that there is this history of claims. The FDA has a lot of latitude and kind of saying, here's how we're using that jurisdictional hook, right? You don't even have to necessarily make claims about your specific product, but if people know, oh, people are buying that product because everyone knows that it's great for headaches, everyone knows that it's great for, that has been enough in the past for the FDA to say, hey, that's an FDCA violation and we're going to prosecute you.
And the reason I specifically, just wanted to clarify that you're talking about federally legal interstate commerce is because I think the majority of the push towards interstate commerce among current licensed operators is happening at the state level, and it's state law reforms that are going to be most relevant here. And so, when I've gotten the question,
hook, though.
I don't think that at that level, a move to Schedule 3 moves the needle significantly at all. I think that the push in the states where there is a push for interstate commerce pre-federal legalization is going to continue. And I think that more than anything, the rumored Garland cannabis memo that that is supposedly in the works has more likelihood of moving the needle on that score than any move to Schedule 3, largely because state law, depending on what it says, there are 3 states' laws that could literally be triggered depending on the language of that memo. And so, and I've also, seen. Sorry, go ahead, Khurshid.
But again, that presumes that the Garland memo would essentially be a statement of federal enforcement priority that says, hey, we're hands off now, right? If you are state legal, we're hands off. And so that's what we're talking about, right? And that is the instance in which you would have those state laws kick in. So I think that's important to highlight for folks.
Right. I mean, I think, plenty of nuance there to dive into. But, I also think, I've seen arguments that litigation arguments in the context of the Dormant Commerce Clause would get stronger as a result of a move to Schedule 3. I don't see that. I think only if you are talking about a challenge that is raised by a company that's actually gone through an FDA compliance process and is operating in a federally legal way, does that challenge become stronger? Shane, I see you moving forward. Am I wrong here?
There's been so much said, and I've been just sitting here peacefully on mute. Yeah. I don't think that the Dormant Commerce Clause challenges get stronger with a move to Schedule 3. I do want to second. I want to second and actually add to something that Khurshid said. So first of all, he's absolutely correct that if FDA wanted to, it could assert jurisdiction, it's very difficult to escape. I mean, anybody who's been to law school and understands Wickard v. Filburn and the Interstate Commerce Clause and how that works, you know, I mean, it's a little bit different with FDA, but for all intents and purposes, I don't think anybody could argue that if FDA really wanted to, right, it could find some sort of jurisdictional hook. I mean, look, ironically, one way it could find that jurisdictional hook is that people are rampantly using medical marijuana products to replace opioids, which are a pharmaceutical product. And the whole point of having this one of the main points, I mean, if you go back and read the briefing from the United States in Wright, right, which was hitting this interstate commerce issue square on, you had Ted Olson and Paul Clement, both the U.S. Solicitors General at the time, wrote briefs for the United States in that case and emphasized and danced all over the fact that if you allow any interstate commerce at all in or even intrastate commerce in cannabis at all, then you're going to have opioid replacement. You're going to have pharmaceutical drugs being replaced with opioids. There's really no way to get out of that trap if they really want to come after it. You know, the question is, therefore, what are we going to do? Because that problem persists even when cannabis is descheduled. Okay, that's what we all want. That's what everybody wants, is descheduling, right? If you deschedule, this point becomes the sharpest and most urgent. Therefore, while I might disagree with like the level of enforcement discretion change that might happen with Khurshid on some level, and we could talk about it, right? What we can agree about is far more important, that this is a first step that has objective, good benefits for everybody, right? But it is just a first step. And if we were to sit still after this, that would be a huge mistake. But it would also be a huge mistake not to recognize what a huge step it indeed is.
I don't think anyone pointing out those next steps is necessarily undermining or devaluing the notion that, hey, you know, having accepted medical use is a big deal. It's a huge deal. Of course, it's a huge deal. The tax equity, huge deal as well. Is it progress? Absolutely. Is it better than Schedule I? Absolutely. I think the issues arise when folks who are cheerleading, for rescheduling without, and kind of being dismissive of concerns about, how do we deal with the FDA going forward? It's when they conflate rescheduling with descheduling as though it's a done deal when it's not. It's when they say things like, hey, it's going to solve for banking when it doesn't. It's when they say, hey, it's going to be even better for minority and social equity businesses, when there's not a ton of real evidence for that it's going to be better, any better than it will be for the big companies. That's, I think, where
we have 3 minutes, y'all.
I was going to say, and I want to, Amber, I want to give you an opportunity to comment on this. There was a joint statement that came out from NCIA, MCBA, Parabola Center, Bullpack, SSDP, Marijuana Justice, characterizing this recommendation as, that rescheduling is simply a rebranding of prohibition, not the end of it. Do you think that's the right way to look at this? Can you give us a minute or two on your thoughts on that?
I love a good a good zippy catchphrase. Back in November, when we had the legalization hearing with House oversight, I said in my testimony, rescheduling is recriminalizing. And because it's true, it is not decriminalizing it. It is criminalizing it in a different way. But some really important context is required. I was talking to Congress. I was talking to the people that actually have the power to end the consequences of prohibition, to end the criminal penalties, to end the immigration issues. So it is absolutely imperative that we are directing our energy at calling Congress to action, because the reality is, whether we rescheduled or descheduled, this isn't going to fix any of that. And so where I would love to see energy go is, hey, Congress, no matter what the Biden administration does, you have a duty to fix this mess that you created, and putting the pressure there, and to open the doors of communication with the administration to try and ensure that anything that supports this process becomes, that we have the most that they stretch to the edges of their authority. The administration pushes to the edges of their authority to implement the changes that they can within the law, but to understand that their ability to do so is highly limited. And for a prohibitionist, drug-fearing, drug war champion president to turn around and to do this, and to provide a step that really does take a big giant hunk out of the federal government's position on prohibition, it's a big deal. And I would love to, again, make sure that folks are directing the smoke in the place that it belongs, which is truly Congress.
And so I want to do a quick bit of housekeeping here. The only person I haven't confirmed can stay over is Amber. And, you know, I'm hoping that I can guilt her into doing so as well. I did want to give Shahida a minute real quick. This is a great discussion. We obviously have a ton of people here. So we're going to roll through it and try to answer as many questions as we can until we'll put a hard stop at noon Pacific. But Shahida, can you let folks know how they can find this content if they have to jump off early?
Yes, absolutely. So this webinar will be posted to the INCBA YouTube page. And we're also going to be sending a follow-up newsletter email blast to the registered participants of today's webinar and to our membership, which will include a link to that video as well as the supplemental written materials that you mentioned.
Wonderful. Thank you so much. And, don't forget IP Symposium, September 28th, 29th. Be there, be square. Montreal, Canada. Rock and roll party. All right. Thanks so much, Shahida. Okay. So I'm getting back into our fun because we were right in the middle of a deeply important topic. And Shane, I think you've written a little bit about this, and from your perspective, is there more, because one of the concerns raised is broken promises by the Biden administration to decriminalize cannabis. From your perspective, could the Biden administration have done more here?
That's a really good question. I guess there's always more that they could have done, but I think the equally important to emphasize is that there's more they can do. We're not done yet. We still have a Biden administration. And I think it's so important. This is why, again, I mean, I keep harping on it, but if there was any group that needed to hear this over and over and over, it is this industry and this movement, which is that we all need to work together to try to get those results. And Amber's exactly right to focus on, the smoke, as she said, on Congress. And to the extent that you want to see more out of the Biden administration, I think, they've done a ton. They've done infinitely more, basically, than any other administration. If you exclude the Cole memo at the federal level, if you see that as dramatic progress, it's literally infinitely more, right, than any other administration. So, and that's not just with this move. It's also with harm reduction generally, the focus on science, many things. The reason I say they could have done more is because that's basically always true, right? They could have put more emphasis. They could have a press conference every day about it until it was fixed. But realistically, I'm not here to who am I to fly spec a president of the United States on something like this? All I can tell you is that what they have done is historic, and we all want more. And so you think about it. Are you going to get more out of them by just criticizing the hell out of them left and right? Or should our movement be joining hands with them and working toward the progress that we all want? I think the answer is obvious. But I'm no political expert. I defer to Amber and Khurshid, on how we might go about doing that. Look forward to working with them on doing that.
And Khurshid, I'll go to you next, and feel free to include any other comments you have on what Shane and Amber have laid out there. But one of the things that the statement I referred to, one of the points that it raises is that rescheduling leaves in place a system of prohibition that has and continues to disproportionately impact communities of color. How should and can this be taken into consideration throughout the scheduling process?
Well, I mean, that argues for descheduling, right? It argues for revisiting criminal penalties, which are untouched in this process, right? So again, scheduling, moving it to Schedule 3 is not going to eliminate those substance-specific penalties that are in there, and so we're not actually decriminalizing cannabis when we do that. So I mean, I think that, to me, that is the chief way to address the fact that the drug war has ravaged communities of color. So without removing those criminal penalties, we're not actually seeing follow-up, right, on the intentions of the administration, and that's what we want to see. I guess I'll just to kind of respond to some of the other points that were made. Again, like, everyone's agreeing with me that we need to have congressional action, that we need to address the FDCA. That's what I've been saying consistently, and consistently also receiving, feedback that is not, perhaps not bullish enough, not enthusiastic enough, and that the FDA, doesn't have any intention of doing anything that is going to disrupt these businesses, this market. Great. That, again, fantastic. Then, then we should be working, and we should be talking about how we change the FDCA to accommodate the industry, right? And the FDA has actually come to that conclusion itself with respect to hemp CBD and hemp cannabinoids, right? They also acknowledge, hey, what we've been doing isn't working, right? We do need a new pathway, and so they're even acknowledging that, and that's great with respect to hemp. But no one should be looking at someone saying, hey, we urgently need to fix this problem as cheerleading for Schedule 1. That is not what's happening. I think that's where folks start to bicker and disagree, and we lose the unity that we could otherwise have to push forward productive changes, right? So
And
I think
Kaliko's made the point in the Q&A that in fact the statement reflects an entire coalition of groups working together and trying to raise awareness around this issue. I'm not anticipating that everyone on this panel will completely just agree with that sentiment, but I did want to make that point here.
So
Amber, sorry, go ahead, Amber.
About the president going back on his promise again. We can't keep. Yes, this doesn't end the criminal justice penalties or decriminalize, nor does descheduling. So again, we have to look at the limits of the president's authority. He's still in office, and if he is alive and breathing, will likely be in office again for another term. And so there is a long way to go, and there is still opportunity to inspire Congress to action. There are still other things that can be done. So while I would love to see descheduling and the end of prohibition, that is a process that I don't think there is any universe in which any administration is going to go from one to removal. I don't see any president or administration being able to make that leap, just because of what's required and how this Schedule 1 status really does hinder your ability to move. So again, I think,
I mean, that sort of brings the question that I was about to ask you, which is, I mean, it seems like it's to some extent this discussion's a referendum on incrementalism as a strategy for the cannabis movement. Do you think that's the right strategy?
incrementalism is really generally pretty unrewarding. It's small, it's not glamorous and big and sexy. You don't always get to like stand there next to the politicians with the big thing and the signature, and then it's often really unsexy. And then it's hard to explain to the press why this is important. But when it comes to cannabis reform federally, I think unfortunately this path is going to be incremental, because right now we have a bunch of old scared people who still think that cannabis is a gateway drug and that it's gonna like make your daughters turn into jazz musician, rapper loving degenerates. So that's what we're working with. We're dealing with people who are still full of fear and hate. And so to move them, that's not gonna happen in like a swoop. We're gonna have to sneak some stuff in. We're gonna have to push what we can administratively, and then hopefully one day they will die off and we will get new people in there. We will influence the hearts of the ones that we can, and then we can make bigger progress. But I don't think that cannabis has ever really had a path from Schedule 1 to complete removal and decriminalization. Not with where we are. We are, in a lot of ways, when it comes to social issues and our recognition of the harm of our government's policies on people of color, we're going backwards in a lot of ways. So again, I think our pathway is, as unrewarding as it is going to be incremental to this. And I would much prefer to keep marching forward incrementally than to sit and have the status quo remain.
Anybody disagree with that or have anything they want to add?
I have a couple of things to add if I could.
Yeah, of course.
So I've just looked into this incrementalism thing, and it turns out, I'm not a historian, but a lot of big changes in United States policy, entrenched policies, especially those that are entrenched because of systemic racism and other, horrible moral cancers on our society, have changed incrementally, if at all. And there are many examples in history of times where good, well-intentioned efforts to push for more or to be like incrementalism isn't enough have actually objectively stalled major progress and things that affect people's lives for decades. One example that I came across was, I was looking at Senator Ted Kennedy's, greatest regret, at the end of his life, and it was not joining a push for healthcare reform that was being pushed by the Nixon administration. And it's not that he didn't think that Nixon's, it was maybe it wasn't single payer, but it was very progressive for the time, right? And far more progressive than anything we had up until Obamacare, right? And Kennedy was like, listen, I don't want to push for that. I want the full, burrito here. I'm not into this incrementalism business. And so he basically quashed that proposal that Nixon had put forward. And if he had joined it, there's, speculation that it probably would have succeeded. And at the end of his life, that's what he regretted more than anything, because it ended up being decades later. I mean, that just ended up getting shelved. And we've all just been totally screwed with a healthcare system that's, it starts to rival cannabis for, one of the most absurd areas of American policy out there. Right. And so that's just one example. There are many, many others. And, I'm not in a position to tell people what they should advocate for. And I'm certainly advocating aggressively for more changes along many fronts, both here and in other areas. But I would just say that you should not let the perfect be the enemy of the good. When you've got an administration, you've got some momentum for the first time in decades, what we should all be doing is helping, Sisyphus push the boulder over the hill here. Oh, and I have a 4.5-year-old daughter, and I hope she becomes a jazz musician. That's all.
I will occasionally let perfect be the enemy of good when it's not that good. And I think, again, if we're looking at, and I think the fears are legitimate if you think that it is not good. But here, I do think, again, the sum total is good. I think sometimes when it comes to incrementalism, that phrase is used to say, get comfortable with this incrementalism and stop pushing for the bigger thing, when the reality is, it's okay to push back against it if the thing that people are saying is good is not good. I lost quite a few friends in the position that I took when I was an MCBA that we took when I was at MCBA around the original States Act. Khurshid remembers that. I was chased down in the halls of Congress, but glad that happened, because again, I think it forced a different type of discussion around what federal policy would look like. But this is a situation where, again, I think if you're looking at it objectively and just looking at the historical context of what the agencies do and the division of authority and where the decisions and the actual changes will come from, ultimately, that the sum total really is good. I haven't heard a lot of factually supported arguments against or towards why this is bad. I've heard a lot of fear and speculation, and some of them justified, but in terms of saying, hey, this is something that will technically be bad, and this is how I'm substantiating it. I'm just not seeing a lot of those arguments come forth.
Khurshid, anything, final word on this point?
Sure. I mean, you know, I can cite another example, right, where incrementalism would have been a better approach, right? And that I want to look at the Safe Banking Act, right? I think we had an opportunity and we blew it, and that pains me, and it still pains me, and you know, but I think it's a mistake to then say, well, anyone who, again, is not kind of unreservedly cheerleading for rescheduling and conflating it with descheduling is somehow critical of incrementalism, right? I mean, the proposals that I've made and what I've written, I think are the essence of incrementalism, right? We're saying, okay, great, this is good, but we can't stop here. We still have a lot of work to do. And here is some specific things that we need to do, some specific issues that we have to grapple with, in order to ensure that we continue forward progress, right? And that, to me, again, the essence of incrementalism is to say, here's the steps that we need to take, and these are bite size, right? I don't say anywhere in what I've written, hey, if we can't get descheduling, then rescheduling, you know, shouldn't be pursued, right? I just think that we need to be very thoughtful about moving forward, and that we do need to understand the hazards ahead and plan for them, right? Again, I don't think that's a rejection of incrementalism at all. I think that is the essence of incrementalism.
And I think it's an important point, and I will again, and Kaliko, I'll thank you for being so active in the chat. And it's a point that Kaliko is making here in the Q&A as well, that from his perspective, and I imagine speaking on behalf of MCBA, that it's less a question of incrementalism as such as it is about this particular incrementalism that he said being pushed by very specific groups of entities to achieve something that they weren't able to achieve through incremental 280E bills.
This is something that, let me speak to that, because again, that requires a lot of assumptions. This process, I assure you, had nothing, the impetus for this had nothing to do with industry. Industry has had minimal sightline into this process, and that sightline hasn't even come in until maybe the last 6-ish months. But industry's ability to engage in and influence this process has been non-existent, or really, really minimal. All they're getting is sightline. So the idea that they have turned and invested all this money is just not true. That isn't who's been driving this process. So this isn't a situation where the MSOs are, we can't get what we want, so we're gonna. So is there a shift in terms of focus? Yeah, because this is working right now, or it appears to be working. So of course people are going to turn to say, yes, I love it, I support it. But in terms of whether or not they have had an influence over this process since the beginning, it's just not true. Their ability to influence this process, as I've spoken to people within the process, they really haven't cared what industry had to say about any of this.
I suppose, you know, incidental, you know, education here as well on where to put your lobbying dollars. All right. So yeah, talk to Amber. There you go. Incrementalism, you know, of course, you know, implies a step-by-step movement towards a better future. Let's assume HHS has its way and cannabis is rescheduled to Schedule 3. As my final question, I'd like to hear from all of you, and it's a three-parter, looking 10 years into the future. One, how will that move be popularly viewed? Two, how will it have impacted the cannabis legalization movement? And three, how will it have impacted the cannabis industry? Khurshid, I'll start with you.
Well, it's a tough question to answer, very speculative, but I think if we do actually reschedule, rightly so, this will be viewed as a turning point for U.S. Federal policy and cannabis prohibition, right? And finally accepting that there and saying that there is accepted medical use is a milestone. It's a huge one, and so I think that's how it'll be viewed if it actually happens. How will it impact the cannabis legalization movement? Well, I think that we're unfortunately probably going to continue to see a bit of a disagreement and sparring among different proponents. But I think by and large, as long as this results in further work, as long as this is not a stopping point, but is a waypoint on the way to descheduling, then this will be viewed very positively, right? It's if we don't do that, I think the legalization movement will have we'll have lost some momentum, right? So I think that we just can't stop here. As long as it's not a final destination, but a waypoint, I think it'll benefit the cannabis legalization movement. How will it impact the cannabis industry? Again, if we do this and we do it with the foresight needed to pave the way for reasonable, sensible federal regulation of these state cannabis products, then I think the impact will be positive, right? If we kind of say, well, we won and call it a day, and we don't, and we rely on things like, enforcement discretion or even executive agency policies, which can be yanked away like we had with the Cole memo, then, not so good, right? So I think there's a lot of what ifs there, even if we do have rescheduling by the DEA.
Amber?
Yeah, I would say largely that again, I echo what Khurshid had to say there. I will say though, I don't, I agree that this can't be the stopping point. But I think it's important to recognize again that I hear a lot of concern around, and there's just no incentive to move forward. Some of the biggest boogeymen that people in this advocacy space here and that folks fear in cannabis actually will not accept anything short of complete legalization and descheduling. So a lot of the interest, big banks, a lot of big industries won't participate in this industry until it is legalized. So while that is also traumatizing, it is also, there is going to be money and political will being used to push this forward. And while we have a beautiful contingent of criminal justice and drug policy reform individuals that are and organizations that are pushing forward for legalization, collectively, our will as an industry and the resources that are going into comprehensive bills and legalization haven't been tremendous to start with. And I hope that this actually has the opposite impact and maybe inspiring folks to take that action and to start actually investing in their ideas and putting forth their ideas for what the industry could look like, because legalization is the easy part. What this framework for regulating this product and doing it equitably and doing it in a way that minimizes regulatory burdens, that is the hard part. And we haven't collectively in any part of our advocacy, with a very few exceptions, started actually laying out what that looks like. And so I think the immediate impacts are going to be good once passed and things are implemented. And if we get the 280E, that alone could help to stabilize an industry that is really, really, really struggling right now. Maybe clients could pay their bills and, I don't know. I'm in safe company.
I think we'll all second, third, and fourth that sentiment. Sorry, I didn't mean to cut you off. If you had more you wanted to say, otherwise I'll turn to Shane for the final word on that question.
Yeah, I mean, I'm not going to go through all of it because I agree largely with what Khurshid and Amber said. I guess that what I'll say is for the industry, I think in order to look at what to measure progress 10 years forward, you have to look at what will happen, which is speculation, but then you also have to look at the opposite side. If it hadn't happened, and play it out 10 years, right? And right now, I think that without major changes at the federal level, the industry is headed for bankruptcy and takeover here eventually within 10 years, the vast majority of it, I would imagine. So there needs to be something that would change. And because I think that this change will, allow it to keep fighting for another day, hopefully, if we continue pushing in the right direction, that by itself is literally existential threat addressing, and therefore is unquestionably positive. I also agree with Khurshid and Amber about, like, historically, there's just no question. If this isn't positive, like whatever was, I mean, it will be, it is. And I think people will see that more and more as time goes by. And then finally, just for like reform, generally, I really do believe this. That is up to us. It's up to, I'm new to this game compared to the people who are still on the line and my co-panelists and you, Jason. Like, I can't tell you guys anything about this. All that I can say is that we need everybody who's gotten us here to double down now. And it's easy to get exhausted and it's easy to get divided. And that is what the enemies of any social movement need and want. Right now, Harry Anslinger, Richard Nixon, DEA, Kevin Sabet are not happy about what just happened. And we need to put our foot down on their proverbial throats and get this done. And then we need to push the gas down even harder. And the more we come together and the more that we work strategically, all of us, the better off we're gonna be. Because I'm gonna do that regardless. But like I said, I'm new and I need the collective wisdom of everybody, not just those who agree with me, which seems like are few sometimes, but especially those who've been doing this longer and have more experience and know. And that's why I've asked for conversations with a lot of those people. And I hope they'll take me up on it, because I want to be behind them and supporting them as we move forward.
Thank you so much. And as great a segue as that would be to just wrap us all up, and there was a time, there's so many questions. I apologize to everyone whose questions we didn't get to. Even going a half an hour over, there are so many issues we haven't gotten to. There was a time when I was thinking I would get to ask you all to choose your favorite question and answer that one. We don't have time for that now, but there's one that I feel remiss we haven't gotten to, which is from Sarah Niram. What are the rescheduling implications for medical patients in current state legal markets? So like at a practical level, someone who's going in and buying medical cannabis now, what's the practical implication of a move to Schedule 3 for them?
I don't know that there is any, right? I think, and this may be something Amber pointed out, businesses that are currently violating Schedule 1 will continue operating. They'll just be in violation of Schedule 3 and potentially, also the FDCA, right? Which is, again, that's been true from the start too. So practically, like, no effect, right? I don't think that all of these companies are going to say, all right, well, now that it's Schedule 3, now we'll go get a DEA license and we'll, I don't think that's the case, right? So I don't foresee any immediate impact just from rescheduling. Okay, I mean, again, FDCA enforcement is another issue altogether, but in the immediate future, just rescheduling is not going to should not affect access, presuming that everyone still has the will to operate unlawfully in contravention of federal law.
Great. Shane, looks like you wanted to add something to that.
Yeah, just a couple of things. I mean, these are indirect impacts, but I think that they're important. First of all, 280E will put pressure on the completely illicit markets, right? Those that are operating in violation of state law and federal law. And by putting pressure, by making it harder for those illicit markets to compete, you would imagine that it would also mean more medical products getting more research, getting better, having more opportunity to be brought to market. So those patients might have, a greater diversity or higher quality products at their disposal potentially. And then I think that also just the influx of money does roughly the same thing. So when 280E gets fixed, you have more money. When companies have more money, if we're smart as a movement, and these are kind of issues that are more up Khurshid's and Amber's alley than mine, but I think that common sense says that if we as an industry have more resources to be able to devote toward common sense reforms and how to regulate appropriately, we can get better products to patients and make them more secure in their hands. And that's kind of what we all want. So while it is admittedly indirect, I do think that patients can expect sort of brighter days ahead to some extent.
Wonderful. I want to just effusively thank you all for this discussion. This has been tremendous. And I think it's reflective of the amount of complexity and nuance around what this all would mean, who it would benefit, how we should feel about it. That, you know, we've spent 2 hours on this discussion with some of the best minds, you know, in this industry, who have done some of the most thinking on this, and it still feels very incomplete. And so I'm sure there will be more discussion. In fact, I think it's likely that at our cannabis law sessions at MJ BizCon, we will revisit this issue. So hopefully we'll see you all there. I'll hand it off to Shahida to take us home.
Thank you, Jason. Thank you to our panelists, and thank you to everyone for attending. We hope to see you at our next webinar or in-person event soon.
Thank you.
Thanks, everybody.
Thanks all.